Geoffrey Wayne Clark, over a series of 3 trials involving 3 separate sets of allegations. You were convicted of 17 charges of theft, 4 charges of obtaining financial advantage by deception, 1 charge of knowingly dealing in the proceeds of crime, 2 charges of perjury, and 1 charge of giving false evidence. The total amount of funds you dealt with dishonestly amounted to at least $922,215. Jeremy Wayne Clark, you were tried separately in respect of 1 set of allegations from which you were convicted of 6 charges of theft and 1 charge of false accounting. In addition, you have pleaded guilty to 1 charge of dishonestly obtaining a gain. The total amount of funds you dealt with dishonestly amounted to at least $231,969. You must each now be sentenced for that offending. I'll start with some preliminary remarks with respect to Geoffrey Clark. Geoffrey Wayne Clark, each of the 3 juries that convicted you of these offences comprised 12 men and women who had been randomly selected from the community. Before those jurors were selected, they were told that approximately 20 years ago you had been a well-known activist in Aboriginal affairs and for a time occupied the position of chair of the then Aboriginal and Torres Strait Islander Commission, known as ATSIC. They were told that it is a fundamental tenet of our criminal justice system that jurors bring a fair and impartial mind to the issues to be decided in the trial. They were told that because of what they knew about you or because they disagreed with the view they believed you may have expressed and they could not bring an impartial mind to the trial, then they were required to excuse themselves. They were told if they felt they were unable to put aside any personal feelings or any bias or sympathy that might arise from what they knew about you, then they were required to excuse themselves. They were told that it was critical that you only be judged by the jury on the basis of the charges brought against you and the evidence presented in the trial, not on any information obtained outside the courtroom. They were told that under no circumstances would any juror be permitted during the course of the trial to use the internet or any other means to conduct research about you or any other matter connected to the trial. They were told that, like every other citizen in this state, you were entitled to a fair trial according to law and to an impartial jury assessing only the evidence presented in the courtroom. The juries that tried you and delivered the verdicts which I'll set out below could have been in no doubt as to their obligations to faithfully and impartially decide the issues according to the evidence before them. Now, in sentencing you, I must take a like approach. You must be sentenced in accordance with the rule of law, independently of any outside influences, only on the evidence before me, and without fear or favour. Whilst you must be punished for your offending, like everyone else in our community who falls to be sentenced, you are entitled to a measured, reasoned, and proportionate response to the wrongs you have committed. Jeremy Wayne Clark, as was the case in respect of your father, the jury that separately tried and convicted you comprised 12 men and women randomly selected from the community. Before those jurors were selected, they were told that you were the eldest son of Geoffrey Wayne Clark, and that although Geoffrey Clark was not on trial in that proceeding, his statements and actions would figure prominently in the evidence to be given at trial, because it was to be alleged that he, together with you, engaged in a joint criminal enterprise to steal the funds that were the subject of the charges. Just as in your father's trial, the jurors were told that they were required to excuse themselves if they felt they could not put aside any bias or sympathy or bring an impartial mind to the trial. Your jury could have been in no doubt as to their obligations to faithfully and impartially decide the issues according to the evidence before them. In sentencing you, I must take a like approach. You are entitled to the same measured, reasoned and proportionate response to your offending. Before I summarise the factual basis for sentence, I should set out the specifics of the charges and the jury verdicts. I'll then attempt to provide some context by describing the setting in which the offending occurs. In my published sentencing remarks, which will be released very shortly after I announce sentence, I'll set out 5 tables that specify the charges on the 5 indictments and the verdicts delivered in respect of each of them. Turning then to the setting in which the offending occurred. Geoffrey Clark, you were born in August 1952 and are now 72 years of age. You are a Chup Wurrung man from Western Victoria. You were raised in a community of Kirra Wurrung people living on their traditional lands at Framlingham, the site of a former Aboriginal mission located about 20 kilometres northeast of Warrnambool. The Framlingham community comprises 17 houses occupied by about 65 residents who were in the main descendants of the Clark, Chatfield and Harradine families. The Aboriginal Lands Act established the Framlingham Aboriginal Trust. The Act conferred the land at Framlingham to the Trust and allocated shares to its original residents. 1,000 shares were given to the adults and 500 to their children. You, Geoffrey Clark, received 500 trust shares in the original distribution. The Trust was governed by a committee of management. You were the Chief Executive Officer of the Trust. You were also elected a Commissioner of ATSIC in 1996 and later appointed to as its National Chair. At all relevant times, you exercised a significant leadership role in the community and wielded considerable power and control over the community's expenditure and activities. You, Jeremy Clark, are a Peak Wurrung and Chup Wurrung man who was born in June 1973. You are the eldest of 3 children and of your parents, Geoff and Trudy. From the age of 4 or so, you lived at Framlingham. You took over your father's role as CEO of the Framlingham Aboriginal Trust in the years 2000 to 2004, whilst your father was chair of ATSIC. The Trust is one of the main entities from which money was stolen. There were 3 other associated entities from which funds were dishonestly appropriated. They were the Kirra Wurrung Community Incorporated, KWCI, the Marland Council, MLC, and Gary Word Enterprises. KWCI was established as the commercial arm of the Framlingham community, whilst the Trust received an allocation of government funds in the order of $150,000 per year, overseen by Aboriginal Affairs Victoria. The KWCI was independent of government. KWCI generated its own funds from a number of economic initiatives. It was also overseen by a committee of management, the composition of which virtually mirrored the Trust's committee of management, and it included both of you. The MLC was an association formed to assist Aboriginal people make native title claims and claims for compensation for acts affecting native title. In 2001, you, Jeremy Clark, negotiated the terms of an Indigenous Land Use Agreement, the ILUA, in respect of the Birregurra-Parate pipeline on behalf of the MLC. Now, you reported these matters to the Trust and to the KWCI committees of management on which Geoffrey Clark sat. You informed those bodies that sums paid under the ILUA were held by the MLC on trust, pending identification of the traditional owners entitled to the money. The ILUA generated $150,000, which was paid in 3 equal instalments in July 1999, August 1999, and 20 June 2002. Gary Word is the Aboriginal name for the Grampians. Gary Word Enterprises is the entity that sits behind Brambuck Incorporated and the Brambuck Living Cultural Centre Cooperative at Halls Gap. You, Geoffrey Clark, were the chair of the Brambuck board, You, Jeremy Clark, throughout the 2000s, except for the period 2000 to 2004 when you were working at Framlingham for the Trust, were the CEO manager of Brambuck. You returned to your role at Brambuck in 2005 after ATSIC was disbanded, and your father returned to the position of CEO of the Trust. It is perhaps easier to understand how these offences came to be committed by describing them chronologically rather than summarising each set of allegations from the separate trials. I'll turn first to the acquisition of Framlingham Aboriginal Trust shares. The Aboriginal Lands Act mandated a process whereby trust shares could be transferred and sold between community members and their descendants. All sales of trust shares had to be made at a price fixed by an independent auditor. The prosecution alleged that you, Geoffrey Clark, knew of this requirement, and that was so because you were CEO of the Trust in 1998 when there had been an earlier share redistribution known as the Kickerbush split, for which an independent audit had been obtained. The shares were then valued at between $52.01 and $63.31 each. The manner in which those figures were calculated was set out in an auditor's report provided by Wilson Sinclair to the Trust. At trial, the prosecution alleged that you had determined to acquire a strong shareholding in the Trust so as to enable you to exert considerable influence over community decision making. Robert Percival Clark, one of the original residents of Framlingham at the time share ownership was declared under the Act, owned 1,000 shares. He passed away on 5 December 1997. His sister, Jessie Edith McDowell, was the sole beneficiary of his estate, and you, Geoffrey Clark, were the executor of the estate. Ms McDowell engaged solicitors to assist her. They corresponded with you to enable them to correctly value the shares, and in so doing referenced the Wilson Sinclair valuation report. You told the solicitors the 1,000 shares were valued at $5,000, that is at $5 a share. You subsequently filed legal documents as executor of the estate confirming that the shares were valued at $5 each. In the early 2000s, Ms McDowell decided to sell her shares and liaised specifically with you, Jeremy Clark, in your capacity as CEO of the Framlingham Aboriginal Trust. On 9 November 2001, she signed a formal instrument transferring her 1,000 shares over to you, Geoffrey Clark. You, Jeremy Clark, personally presented Ms McDowell with a cheque for $5,000. A formal instrument of transfer was signed by you, Geoffrey Clark, on 12 April 2002. As a result, you acquired 1,000 shares at a significantly undervalued sum, which at a minimum was $47,010 less than their true value. In consequence, Ms McDowell was significantly financially disadvantaged. I'll turn now to the theft of monies to pay Geoffrey Clark's personal legal fees. In the early 2000s, you, Geoffrey Clark, became involved in a number of complex legal proceedings, and those proceedings variously related to criminal prosecutions concerning an allegation of rape said to have occurred in 1981, an obstructing police charge arising from an incident at the Criterion Hotel in Warrnambool on 2 May 2002, civil actions in respect of 2 sets of historical rape allegations arising in 1971 and 1981, and unfair dismissal proceedings brought by you against the Commonwealth Government in respect of your dismissal from ATSIC. You engaged Cody's solicitors to represent you in these matters. These proceedings, which included multiple appeals, generated legal bills that exceeded $900,000. You, Geoffrey Clark, paid a portion of those bills, something in the order of $400,000, with your own money. You were also able to apply some funds obtained from the sale of cattle you had owned. There was, however, a considerable shortfall. To assist you meet these personal legal fees, a fighting fund was established. Aboriginal and Torres Strait Islander organisations were asked to make contributions to that fund. Brambuck contributed $30,000, Budger Budger contributed $5,000, and Mildura Aboriginal Cooperative contributed $5,000. That $40,000 was the extent of contributions made under the fighting fund. A significant deficit remained. At regular intervals, your solicitors required additional funds to be paid into their trust account to fund the ongoing legal proceedings. In the first and second trials, the prosecution alleged that it was in that setting you both engaged in a joint criminal enterprise to use your influence over the entities in which you held positions to illegally divert funds to pay Geoffrey Clark's personal legal fees. At first, the payments to Cody's, at least ostensibly, were properly accounted for as loans. However, over time, the payments were deliberately and falsely mischaracterised as legitimate expenses. Payments were subsequently described as legal fees expense, com activities expense, and the like, despite the fact that they were not expenses of the relevant entity, but rather payments for the personal legal fees of Geoffrey Clark. Other payments were simply concealed as stock sales income. These payments were made by the bookkeepers of the Trust, KWCI and Gary Word at the direction of you, Geoffrey Clark, or you, Jeremy Clark. To that end, accounting records were kept deliberately vague so as to hide the nature and extent of the sums being advanced. The following payments were made dishonestly to pay for Geoffrey Clark's legal fees. And in my published remarks, I'll then set out the specific details of the 15 charges of theft of which Geoffrey Clark was found guilty, and the 6 charges of theft and 1 charge of false accounting of which Jeremy Clark was found guilty. None of these payments were authorised by the Committee of Management of the Framlingham Aboriginal Trust or KWCI. The community at Framlingham were not aware that these funds were being diverted to pay for Geoffrey Clark's personal legal fees. In total, you, Geoffrey Clark, stole $404,344, $229,344 of which was stolen from KWCI, $150,000 of which was stolen from the MLC, and $25,000 of which was stolen from the Framlingham Aboriginal Trust. In total, you, Jeremy Clark, were complicit in the theft of $231,969, $150,000 of which was stolen from the MLC, and $81,969 of which was stolen from KWCI. I'll turn now to the fraud perpetrated by you, Geoffrey Clark, in respect of real property. On 1 May 2007, you were ordered to pay a considerable sum in respect of one of the 2 civil proceedings that were then extant. By early 2009, lawyers acting for the successful party were demanding payment and threatening further legal proceedings. On 28 May 2009, you applied for bankruptcy. During the period of the offending, you, Geoffrey Clark, owned 4 properties registered in your name and managed by you personally. 519 of Sullivan's Road, Wangoom, 81 Scott Road, Halls Gap, and 1865 and 1867 Hopkins Highway, Purnham. Investigators located a folder in your home marked Jeff's House, Land Info, Purnham, Halls Gap, Hopkins, Land. In it, they found you kept records of loan repayments and expenses such as rates, utilities and insurance on these properties over many years. You declared the rental from these properties on your personal tax return. You notionally divested yourself of these properties and claimed they were assets of the Framlingham Aboriginal Trust. In doing so, you manipulated the accounts of KWCI and the Trust to outsource the costs of maintaining the properties. The community was unaware that its funds were being spent on your personal assets. Between 13 September 2005 and 3 June 2015, you dishonestly caused KWCI and Framlingham Aboriginal Trust to pay expenses such as rates, electricity and water bills on your property at 81 Scott Road, Halls Gap, to the value of $27,354.45. Between 27 February 2006 and 23 September 2011, you dishonestly caused KWCI and the Framlingham Aboriginal Trust to pay rates on your property at 519 O'Sullivan's Road, Wangoom, to the value of $3,056.61. And between 27 February 2006 and 10 April 2018, you dishonestly caused KWCI and the Framlingham Aboriginal Trust to pay expenses on the two neighbouring properties at 1865 and 1867 Hopkins Highway, Perth, to a combined value of $25,609.96. By outsourcing the payment of these expenses to the Trust and KWCI, you dishonestly obtained a total of $56,020.92. And turn now to a charge of perjury of which you were found guilty, Geoffrey Clark. On 16 January 2007, you committed perjury by swearing an affidavit in which you stated that you, and I quote, did not own any real estate property, unquote. You claimed that the properties at Wangoom, Halls Gap and Perman were not yours, but rather had always been owned by the Framlingham Aboriginal Trust. You made this claim in anticipation of your bankruptcy in order to protect your properties from the pool of assets to be liquidated in payment of creditors. I'll turn now to the first part of the allegations concerning personal profit taken from Framlingham community assets. On 13 April 2009, Rhiannon Mortimer commenced renting a property owned by KWCI, known as Turum Stones. You, Geoffrey Clark, entered into the lease agreement with Ms Mortimer on behalf of KWCI. Over the next 2 years, Ms Mortimer paid $16,800 in rent. However, only $1,950 of that amount was deposited into KWCI's bank account. In pocketing the balance, you stole a total of $14,850 from KWCI in 28 separate instances. Turning now to the fraud on the Commonwealth Department of Families, Housing, Community Services and Indigenous Affairs, known as FARCASIA. This concerns you, Jeremy Clark. On 22 July 2009 and 1 October 2009, you, Jeremy Clark, submitted a quote and an invoice, respectively, to FARCASIA with the intention of obtaining $10,780 from that Commonwealth entity. That conduct was dishonest because you represented to the department that the money was to be spent on repairing and maintaining houses at Brambuck, Halls Gap, in accordance with a government grant directed to improving houses in Aboriginal communities. The $10,780 was paid to Brambuck as part of a larger grant of $120,780 for repairs and maintenance to 10 designated properties at Brambuck. You authorised the expenditure of $10,000 on the conversion of a garage to a home office in Ballarat. That office was constructed for the benefit of your younger brother, Aaron Clark, in October 2009. The Ballarat property was not one of the 10 designated properties subject to the grant. I'll turn now to the unauthorised transfer of $400,000 by you, Geoffrey Clark. Leading up to May of 2011, a number of complaints had been received by Aboriginal Affairs Victoria in respect of you, Geoffrey Clark, relating to your management of the Framlingham Aboriginal Trust. In consequence, an independent auditor had been commissioned and a new administrator foreshadowed. Perceiving that your grip on the trust was very much at risk, you instructed the trust bookkeeper to transfer $400,000 to KWCI without the authority of the Trust Committee of Management. Indeed, you failed to mention the transfer of this money at a meeting of the Trust Committee of Management held shortly afterwards on 6 May 2011. At the time of the transfer, you still retained your power and influence at KWCI. The Framlingham Aboriginal Trust incurred a loss of $400,000. Ultimately, the money was returned after civil proceedings were issued by the Trust. I'll now turn to the offences of perjury and false evidence in respect of examination of you, Geoffrey Clark, your assets. Sometime before November 2012, the Framlingham Aboriginal Trust issued proceedings against you, Geoffrey Clark, seeking to resolve a dispute in respect of its shareholding. On 21 November 2012, you swore in an affidavit in that proceeding in which you swore an affidavit, I should say, in that proceeding in which you lied about the extent of your trust shareholdings. And you did so by asserting that you held only 100 shares in the trust and that you had transferred 1,900 shares to your son, Jeremy Clark, which had been approved by the Committee of Management at a meeting held on 1 May 2002. Those assertions were false. You in fact owned 2,000 shares and held an equitable interest in a further 800 shares that had been gifted to you by your grandmother, but which had not been formally transferred. Moreover, there was no legitimate transfer of 1,900 shares to your son. 1 May 2002 was a significant day in the life of the Framlingham community, the Warrnambool Race Day. At trial, the jury was satisfied beyond reasonable doubt that there had not been a Trust Committee of Management meeting held that day. On 30 July 2013, you gave false evidence about the extent of your Framlingham Aboriginal Trust shareholding in the Federal Court of Australia. At that time, you were examined on oath as to your assets in the context of your application to be declared bankrupt. You repeated the same false assertions I have set out above, and I'll set out precisely what you were asked and how you answered in my published remarks, where I will set out that evidence verbatim. I'll turn now to the second part of the allegations concerning personal profit taken from Framlingham Aboriginal community assets. Personally, I should say in April 2009, the Framlingham Aboriginal Trust purchased an eel fishing licence known as EA8. In June 2009, ownership of the licence was transferred to a private family company known as Ma Natural Products Proprietary Limited. The only directors of that company were you, Geoffrey Clark, your wife and 2 of your sons. Thereafter, you dealt with Fisheries Victoria in respect of that licence on behalf of MNP. The Trust also owned a second eel fishing licence known as EA9. Both EA8 and EA9 were fished by the same fishermen in the period December 2013 to July 2015. You collected regular cash payments from those fishermen in respect of both licences. At trial, the prosecution could not establish with precision what sum of money you dealt with as the proceeds of crime in respect of the EA licence. However, The fishermen estimated approximately $105,000 was paid in total, and that about a quarter of this, about $26,000, was paid in respect of the EA8 licence. The total value of the frauds committed by you, Geoffrey Clark, amount to $922,215.02. And that figure does not include the offence of knowingly dealing with the proceeds of crime, where the quantum dealt with could not be ascertained with any precision. The total value of the frauds in which you, Jeremy Clark, were complicit amount to $231,969. That calculation does not include the offence of false accounting and the offence of dishonestly obtaining a gain from a Commonwealth entity. I turn now to the impact these offences have had on victims. Victim impact statements were provided by Jeff Possum Clark-Ugle, redacted, Billy Joe McGuinness, redacted, and Edward Ted Laxton. For Mr. Clark-Ugle, this offending has undermined his trust and faith in the governance of his community. That community remains fractured and is still yet to recover. The share register fraud distorted voting entitlements in the trust and caused he and his family significant detriment. The theft of monies for Jeff Clark's personal gain had not just deeply impacted him personally, but also the wider community, which would have otherwise benefited greatly from the use of those funds. Mr. McGuinness felt strongly about the impact of these frauds. In his view, they had engendered a great deal of resentment and division within the community. He said that you, Geoffrey Clark, had, and I quote, not just spiritually hurt our people, but financially raped us, unquote. Edward Laxton explained that he's now aware that his mother was deceived as to the price of the shares you, Geoffrey Clark, purchased. He says that if she had been paid their real worth, his mother would have had a much better and more comfortable senior life. He very much regrets that she was deprived of that opportunity. You should both understand that the impact this offending has had on these victims and the wider Framlingham community is an important consideration in formulating the sentence to be imposed. Having now summarised the offending and the victim impact statements, I will turn to your personal circumstances and to the submissions as to the appropriate sentences to be imposed. I'll start with you, Geoffrey Clark. You were born in Melbourne in 1952. Your mother, who was Aboriginal, was from the Framlingham area, whereas your father had a Scottish background and worked as a painter and docker in Melbourne. Although you had some contact with your father into your teens, he did not play a meaningful part in your life. Your mother worked in various factories in inner Melbourne. She sent you back to Framlingham to be cared for by your grandparents when you were between 3 months and 6 months of age. Your counsel explained that it was common practice to send children, particularly those of fair complexion, back to places like Framlingham to be raised in the bush by extended family as a way of avoiding government policies in place at the time that forced the removal of Aboriginal children from their families. You were brought up by your grandmother Alice. During the years you were raised at Framlingham, conditions were very basic. You lived in a small timber house built in the 1930s with no water, no sewerage and no electricity. You have 2 older sisters who were also raised at Framlingham. They went on to live successful lives in the region and raise strong families. You keep in regular contact with them. In 1970, your mother returned to Framlingham after she had formed a relationship with A. Brian Davis. She remained at Framlingham until her death in 2020. Mr. Davis provided a personal reference in support of your plea in which he described arriving at Framlingham to find the community in what he said was, and I quote, abject poverty and in total decline, unquote. He and your mother started the first health service, which later became the Cure Health Service. He says that as administrator of the trust, you were instrumental in introducing and improving infrastructure such as sewerage, water, waste removal, housing and land management. As a child growing up at Framlingham, you were taught to hunt and fish using traditional methods and absorbed Aboriginal culture under the guidance of community elders. There was a school at the Framlingham Aboriginal community where you completed your primary schooling. You then went to secondary school in Warrnambool, where you completed Year 11. You found the transition to schooling in Warrnambool challenging. Racism was the norm, and you were regularly taunted and bullied about your Aboriginal identity. It was often suggested that you were too white to be Aboriginal. I was told that was a theme of abuse that continued to be levelled at you throughout your adult life. Although the prejudice and racism you experienced as a child and into your early adult years was traumatising, I was told that you now feel it also had the effect of strengthening your sense of identity and pride as an Aboriginal man. It motivated you to become politically active. You excelled at sport, particularly football. Your talent enabled you to gain acceptance amongst your peers and the wider community. You played in Aboriginal representative teams at both state and national level, and you were named 5 times in the All-Australian Aboriginal football team, once as captain coach. Not long after finishing school, you met your future wife, Trudy, around 1971 and travelled with her to Perth, where you played football for about 3 years at a high level in the West Australian Football League. You played with Claremont and then Subiaco. You then spent a further year playing in Adelaide for Norwood before returning to Framlingham at the age of 26. Your first son, Jeremy, had been born in 1973 as you were making your way to Perth. Your second son was born at Framlingham in 1981 and the third in 1987. At the time of your return, living conditions at Framlingham remained significantly disadvantaged. Few in the community had jobs, there was little money and infrastructure, there were chronic health problems and significant drug and alcohol abuse. In 1979, you first took on the formal role of administrator at Framlingham, replacing your cousin, Lenny Clark. At that time, your only real-life experience had been as a footballer, and you had nothing in the way of skills or training to equip you to perform that sort of managerial role. Nevertheless, you threw yourself into the work. As Mr. Davis explained in his reference, you were instrumental in bringing families back to Framlingham and reconnecting them with their country. Through your hard work and advocacy, I was told that you achieved enormous improvements in the community's infrastructure, such as sewerage, waste removal, water and housing. You were also instrumental in establishing a self-sustaining economic base for the community through the acquisition of things such as stock and farm assets and the like. As part of your work, you started to connect with other Aboriginal organisations. For example, you would attend land council meetings at the state and then national level. Your interests quickly grew to encompass Aboriginal advancement and self-determination more broadly. During the 1980s, you became particularly active on issues such as native title and the over-representation of Aboriginal people in the criminal justice system and prisons. In 1985, you attended the United Nations in Geneva with the Federation of Land Councils. You were involved in developing and drafting the articles of the United Nations Declaration of the Rights of Indigenous People. I was told that by 2007 that declaration had been ratified by 184 nations. You attended the first meeting of the National Aboriginal Health Organisation in 1985 and became a founding member of the National Coalition of Aboriginal Organisations. Among the many causes you advocated, you were particularly active in campaigning for a treaty, for native title, and in establishing the Brambuck Living Cultural Centre at Halls Gap. The Aboriginal and Torres Strait Islander Commission was established in the early 1990s. You were elected to the board of ATSIC in December 1996 for a 3-year term as the Victorian Commissioner and native title spokesperson. In December 1999, you became Australia's first and only national chairperson of ATSIC. Your counsel took me to a speech that you had made on the steps of the Sydney Opera House at an event known as Corroboree 2000, which was described as a ceremonial gathering of Indigenous and non-Indigenous Australians to exchange commitments in the lead up to the centenary of Federation in 2001. The speech called for reconciliation, but on just terms for First Nations peoples. The following day, there was a walk for reconciliation across the Sydney Harbour Bridge, attended by as many as 250,000 people. You were one of the leaders of that march. During your time as chair of ATSIC, you functioned at a very high political level on the national and sometimes international stage. That came to an end in 2004 or so, in the wake of your conviction for obstructing police arising out of the Criterion Hotel incident. ATSIC was soon afterwards abolished. You returned to Framlingham to resume your role as administrator of the Trust. You worked as chair of the Indigenous Land Corporation, securing a number of properties for the Trust and some of the family groups associated with Framlingham. You continue to be active in Aboriginal affairs. For example, you're a signatory to the Uluru Statement from the Heart. You are a senior cultural knowledge holder and maintain significant cultural responsibilities and obligations within your community. I was told that you're proud of your 3 sons. The eldest, Jeremy, was the first person from Framlingham to finish Year 12. Your middle son is now an adjunct professor at the Australian Graduate School of Management at the University of New South Wales, and your youngest son is a practicing lawyer. You are a grandfather to 9 grandchildren and now have a great-granddaughter. Turning to character evidence concerning you, Geoffrey Clark, whilst you do have a previous criminal history, it essentially comprises street offending when you were much younger. There are no prior matters involving dishonesty. I do not regard those matters as relevant to forming sentence. There were 27 personal references tendered in support of your plea, and they speak of a side to your character that was not particularly apparent during the trials. Many of the authors of those references shared with you the struggle in advocating for Indigenous rights throughout the 1980s, 1990s and into the 2000s. Almost universally, those references laud the commitment and strength of leadership you showed through those years, often in a hostile environment. Clearly, you've given much and earned the respect of many. Those close to you perceive that you have been judged too harshly by the outside world and your achievements overlooked. Your years in the public glare have taken their toll on you and your family. Your health is not good. According to your treating general practitioner, you suffer from an array of chronic conditions such as diabetes, glaucoma, hypertension, truncal obesity, osteoarthritis, gastroesophageal reflux disease. You require multiple medications to manage these conditions, and I accept that imprisonment is likely to be more burdensome for you. You remain actively involved in managing community land and assets. You volunteer more than full-time hours each week to the management of land and farm properties owned by KWCI and Brambuck. As I've indicated, you also have significant cultural responsibilities attached to managing that land. For example, you are a senior knowledge holder for the native title Eastern Maar community, and you remain involved in active native title claims. Turning to submissions made on your behalf, Mr. Geoffrey Clark. In submissions on your behalf, Mr. Kenny, who appeared with Ms. Buckley, acknowledged that the jury verdicts meant that you had offended over a long period of time, that you had engaged in multiple acts of criminality, that you had obtained a substantial sum of money, and in so doing breached the trust of your community. It was accepted that general deterrence and denunciation must therefore play an important role in the sentencing process. Mr Kenny pointed out that the quantum in respect of charge 3 on indictment point 3A, the theft of $400,000, had been recovered by the trust, and it was also submitted that charge 2 on the same indictment relating to the obtaining of the undervalued shares involved an amount of money that was essentially a creation of statute which was not realistically capable of being realised. Although previous good character and prospects for rehabilitation play a lesser role in formulating sentence in white-collar matters, they're still very important. And given your otherwise good character, particularly your history of work and contributions to the community, it was submitted that your prospects for rehabilitation should be assessed as being excellent. Your prior convictions were old and of limited relevance. The fact that you pleaded not guilty cannot be an aggravating circumstance. The sentencing principle of totality requires careful application in your case, and it was also put that the offences of perjury and giving false evidence, while serious, were not directed towards a false conviction or acquittal in a criminal case. It was submitted that you are of advanced years and in poor health, and that any period of imprisonment will represent a significant part of the period of life you have left. Moreover, imprisonment is likely to be much more onerous for you than for a younger, healthier person. It was also noted that there had been a significant delay of about 6 years since the time you were first charged in respect of these matters. You've not reoffended, and you've lived with the uncertainty of these matters hanging over your head throughout that time. Counsel argued that in addition you've also been subject to significant adverse publicity, a good deal of which was said to be unfair or unwarranted. It was submitted, given your age and ill health, your immense contributions to the community, the delay in the resolution of these proceedings and the public opprobrium to which you have been subjected, that the appropriate penalty should include a lengthy period of supervision in the community. Counsel put that, and I quote, "Whilst it is acknowledged that the court may determine that Mr Clarke must be imprisoned, it is submitted that the period of supervision could be facilitated by a community correction order." Unquote. I took that submission to suggest that any sentence of imprisonment imposed could be combined with a community correction order, in which case the imprisonment component could be no longer than 12 months. Turning then to the prosecution submissions concerning you, Geoffrey Clarke, Mr Lewis of Senior Counsel, who appeared with Ms Jones and Ms Adams, submitted that your offending represented a significant abuse of your position as leader of the Framlingham Aboriginal community. It was submitted that your moral culpability should be assessed in light of the following. You obtained a significant amount of money, $922,215.02 overall, and committed multiple offences over a period in the order of 17 years. You offended for your own personal benefit, $404,000 of which was to pay your personal legal fees, $14,850 in stolen rent, and a sum in the vicinity of $26,000 from the proceeds of the EA8 eel licence. Some of the offending involved profiting from unfair transactions with other community members, in particular approximately $47,000 in undervalued trust shares. Part of the motivation for these offences was to maintain your power and influence over the community. For example, you stole $400,000 from the trust, transferring it to KWCI at a time when you faced imminent removal from the trust. You deliberately misled the community as to its ownership of its assets. You manipulated its accounts so as to have your liabilities on your houses paid by the community. And you also told lies in legal proceedings in respect of the ownership of your houses and trust shareholdings. And you also exploited weak systems of governance to extract gain for yourself, and in so doing further weakened those systems. It was put that you treated the funds of these entities as an extension of your own personal bank account to dip in and out of as it suited you. It was argued that your offending was all the more morally reprehensible, having regard to the significant historical disadvantage experienced by First Nations people. Moreover, the money stolen represented money gained from limited government funding and a number of significant economic initiatives undertaken by the community, such as the ILUA. The fact was that money was to be spent, as was made clear in KWCI's statements of purposes, and I quote, to relieve the poverty, sickness, destitution, suffering, misfortune and helplessness of the Aboriginal inhabitants of the area, unquote. It was submitted in some senses you had led a double life, where on one hand you had, quote, done good works, unquote, but in parallel had offended over many years. It was said that you developed a sense of entitlement which illuminated the nature of your offending. The argument that the share price set under the Aboriginal Lands Act was unrealistic was to be rejected. It was submitted that if anyone had the capacity to pay the price set under the Act, it was you. It was submitted that general deterrence and denunciation should carry particular weight in this sentencing exercise, having regard to the well-recognised principles associated with sentencing white-collar crime, which it was submitted applied in these circumstances. The following often cited passage from the judgment of Justice of Appeal Charles in Bulfin was cited in support. His Honour there said that, and I quote, the motivation to engage in conduct of the kind here under consideration may spring from many sources: a position of trust and the easy ability to abuse it, the enormous rewards that may be available, a position of high authority in some substantial enterprise and the offender's assumption the discovery or proof of wrongdoing can be avoided, greed or the burden of funding an extravagant lifestyle, weakness in succumbing to outside pressures to use deceitful means for business ends, and personal or corporate ambition, to name but a few. Whatever the motivation, offences of the kind here in question almost invariably involve a carefully calculated course of conduct over a long period, repeated deliberate acts of dishonesty, substantial amounts of money and, frequently, losses, often tragic in their impact, to large numbers of small investors. The offender often holds a position making it possible or has the ability to disguise or camouflage the conduct in question. Detection is difficult, the investigation of the crime usually lengthy and very expensive, and the problems of trial and proof will frequently be extreme. The results of such considerations, in my view, is that the element of general deterrence will usually carry particular significance in sentencing for crimes such as the present, both in relation to the total effective sentence and the non-parole period, together with the requirement for strong denunciation by the sentencing court, unquote. Typically, white-collar offenders present as unlikely to offend again because their exposure means they will be deprived of the opportunity to do so. In your case, however, it was submitted that specific deterrence should be emphasised due to the persistent nature of this offending and your continuing involvement in the trust. Ultimately, it was contended that only a custodial term of imprisonment involving the imposition of a head sentence together with a non-parole period would be within the range of available sentences. Turning now to Jeremy Clark and your personal circumstances. Your counsel, Mr. Moore, who appeared with Mr. Pine, submitted that understanding your personal history was central to understanding your offending and the important matters in mitigation in your case. You are a 51-year-old man with no criminal history whatsoever. You were born in Mount Gambier at the time your mother and father were travelling to Western Australia, where your father was to play football. You lived with your parents in Perth for 3 years and then a further year in South Australia before returning to Framlingham. As I described in setting out your father's personal history, Framlingham at that time was quite impoverished. There were no paved roads or services, few people had jobs or vehicles, and chronic health problems were rife. Your earliest memories are of living in an old bus without electricity or running water, and over time the situation improved somewhat. For example, you recall moving into a house with electricity and running water just before your younger brother was born in 1981. You attended the Purnham Primary School, which consisted of a single room with one teacher and 22 children across all year levels. When you went to high school in Warrnambool, you struggled with your classwork and had to catch up by learning the things that you did not learn in primary school. Your mother arranged for you to receive some private tutoring to assist you. Not unlike the experience of your father, secondary schooling presented other challenges. You were looked down upon because you were from Framlingham. Racial abuse and bullying was still common. Fortunately, you were a talented footballer and through that avenue made friends. Over time, you became more settled and your grades improved such that you were able to complete year 12 in 1991. Although you were the first person to finish year 12 from Framlingham, further education was not considered a realistic option. There were no teachers or mentors at school who encouraged you to go to university. It was expected that you would go straight into the workforce. For the next 5 years or so, you worked in manual jobs such as farm labouring and helping to protect cultural heritage sites. In 1996, when you were about 23, you were appointed administrator of the Framlingham Aboriginal Trust. That was a challenging job for which you had no training. You suddenly became responsible for managing staff, maintaining housing and rental programs, water, rubbish collection, land management and employment programs. And there are also cultural responsibilities, which included protecting the cultural heritage of a significant coastal area of about 200 kilometres under the Aboriginal and Torres Strait Islander Heritage Protection Act. In addition, there were enterprises set up by the community involving cattle, wood cutting, eel fishing and the like that required oversight. Whilst you were thrown in the deep end, Council explained that you persisted and over time developed the experience and leadership skills that enabled you to go on and play a meaningful role in a number of important Aboriginal organisations. The period mid-1990s to the mid-2000s were extremely challenging insofar as you were not only performing a difficult job, but also dealing with the intense media attention directed towards your father. At the time, you had a young family living in Warrnambool and worked in Framlingham. You were frequently the target of resentment, essentially because you were Geoff Clark's son. As your father attracted controversy, people you thought were friends avoided or disowned you, and you became isolated and depressed. Eventually, you emerged from that period to become a well-respected leader and role model. You are currently employed as a manager at Barber Proprietary Limited, an Indigenous construction company that you had an important role in establishing. Beyond your paid work, you have devoted your time to serving on numerous boards and committees in voluntary, unpaid roles, 15 since 1997. One of the most significant roles you undertook was as chair of the Eastern Maar Aboriginal Corporation, EMAC. During your time in that role, EMAC made a native title claim which resulted in 2 successful determinations in respect of traditional owners' land rights in southwest Victoria. Other roles that you've undertaken included Deputy Chair of the Federation of Victorian Traditional Owner Corporations, member of the Victorian Aboriginal Treaty Working Group, and member of the Victorian Aboriginal Economic Board. You have been involved in 3 significant relationships. The first was a short relationship from which you have a daughter who was born in 1993. The relationship ceased in 1994, but you co-parented your daughter throughout the 1990s. In 2000, you formed a new relationship and married in 2006. There are 4 children of that relationship born between 2003 and 2009. You separated in 2016 and divorced shortly after. Your children now live in regional Victoria and you maintain contact with them. You're presently in a relationship with Katie Phyllis, who provided a helpful reference for the purposes of your plea. She attended your trial and is well aware of the outcome. You have, as she puts it, her full and enduring support. Turning to the character evidence advanced on your behalf, Jeremy Clark, you were described by counsel as, and I quote, so much more, unquote, than the offending of which you were convicted. At trial, you were able to call what was submitted to be compelling good character evidence. And in summary, that evidence was as follows. Michael Reid who was effectively your boss, described how you and he built a joint venture construction firm from virtually nothing, such that it now employs about 100 people. It's the largest Indigenous construction company in Australia, the majority shareholder being the Federation of Traditional Owner Corporations. Mr. Reid explained that starting a business from scratch presented a large number of challenges which you managed to overcome. He said you were integral to the growth of the business. It had won awards in respect of the culture. It had developed and employed about 20 Indigenous staff for whom you were responsible. Dr. Matthew Story, a solicitor and former director of the Victorian Heritage Council, described your work with the Eastern Maar Aboriginal Corporation, its native title applications, and your work in helping to establish a peak body for traditional owner corporations in Victoria. He said you were instrumental in these developments and that you were genuinely committed to advancing the interests of Aboriginal people. On a personal level, Chris Daly, who'd known you for many years as a friend from school, described you as kind, compassionate, honest and intellectually curious. Tanya Elvin gave evidence that she had worked with you in the construction industry over a period of 15 years or so. She stated that you were well respected, well liked and had an excellent professional reputation. Mr. Reid, Ms. Elvin and Dr. Story provided supplementary written references in support of your plea. Their opinion of you had not altered in spite of the verdicts. Beyond that evidence and your partner's reference, a further 19 written character references from respected elders, former and present work colleagues, family, friends and others were relied upon on the plea. Each referee indicated their awareness of the jury's findings. Overwhelmingly, those referees acknowledged your passion, commitment and dedication to advancing the interests of Aboriginal people. In the many years since the commission of these offences, you have matured and developed a working style that emphasises consensus and respect and has achieved tangible results. You've taken on numerous leadership and mentoring roles and inspired many. You are indeed an emerging leader of your community. In essence, your counsel submitted you are a very different person to the person who committed these offences. Turning to legal submissions made on your behalf. Whilst counsel on your behalf accepted that the quantum of funds dealt with was significant, it was submitted there were a number of matters which mitigated your offending, and they were you did not receive any personal benefit, whether direct or indirect. You were not the primary offender or the driving force behind the diversion of these funds. The nature of your participation in the joint criminal enterprise was not clear. It could, for example, have been no more than looking the other way when money was transferred. You did not know precisely which litigation was being funded. For example, the community had a legitimate interest in the funding of the Criterion Hotel incident, much less so in defending the civil rape allegations. And you were, at the time, relatively inexperienced in your role as administrator, and these funds were being diverted to assist your father, a prominent national Aboriginal leader, and it was perhaps therefore easier to rationalise this expenditure as in the interests of the wider Aboriginal community. The charge of obtaining a gain to which you pleaded guilty is punishable by a lesser maximum term than the other offences, 5 years imprisonment. You were entitled to a substantial reduction in that sentence for that offence than would otherwise be imposed by reason of your plea. It was submitted that the circumstances surrounding that offending provided important context. The funds were directed to the installation of a Home Office at Aaron Clark's residence in Ballarat around October 2009. At that time, Aaron Clark was employed by Brambuck in a marketing role while living in Ballarat with his partner and 2 children under 5. Tragically, his partner died suddenly, leaving Aaron Clark widowed in his 20s and having to care for 2 very young children on his own. He was no longer able to commute to Halls Gap to work at Brambuck, and the Home Office was built to enable him to work remotely. Moreover, the funding arrangements with the Commonwealth made provision for over $6,000 to be spent as the organisation saw fit, and that money could have been legitimately directed for this purpose. Those matters, it was submitted, mitigated significantly. None of this offending, it was also submitted, was motivated by greed, and the extent to which the prosecution rely on authorities such as Bulfin relating to white-collar criminality in your case, relating to white-collar criminality. In your case, that reliance should be heavily qualified. It was further submitted that both limbs of mitigation flowing from delay should be given full weight. The delay here has been extraordinary, 11 years from the last offence, but in the order of 20 years in respect of the legal fees offending. There has been extracurrial punishment in the sense that you have had to leave all your leadership positions in the wake of these charges, and you've been forced to remain on the sidelines throughout important public debates involving the Aboriginal community. You were able to marshal some powerful evidence in support of your good character as described above. The submission being that any discussion as to prospects for rehabilitation was moot because you had already rehabilitated. And it was submitted that the legal fees charges can and should be dealt with by the imposition of wholly suspended sentences of imprisonment, which remain open due to the age of the offending. In respect of the Farcasia charge, a Section 19B bond without conviction, it was submitted, was appropriate. Turning to the prosecution submissions relating to you, Jeremy Clark, the prosecution submitted that you had participated in the theft of a significant sum of $231,000 between February 2003 and December 2004. Throughout that period, you had the responsibility of overseeing the administration of the trust and KWCI. You were complicit in a plan to steal such funds as could be gained from KWCI and MLC to fund your father's legal proceedings. In participating in that plan, it was put that you prioritised your own family over the people to whom you owed a duty to serve. That said, it was acknowledged that you derived no personal benefit from your part in this offending. The overall quantum of money stolen in respect of your father's personal legal fees was significantly less in your case, and the role you played was significantly less. It was accepted that your father must have been the driving force behind the scheme to pay his own legal fees. In respect of the fraud committed on the Commonwealth, you again prioritised the interests of your own family, in that case your brother, over your duty as the manager at Brambuck not to make false representations. It was, however, acknowledged that that matter could have been readily dealt with summarily and that your plea of guilty entitles you to a substantial reduction in the sentence and is indicative of remorse. It was accepted that some of the delay during the course of the investigation was undue. However, it should be understood that the investigation was inordinately complex and had generated a police brief in excess of 20,000 pages with allegations of 16 separate fraudulent schemes. The committal had commenced in 2020 but was interrupted by the tragic death of one of the barristers involved and was further delayed by the pandemic. Seen in that light, the delay was more understandable and it was submitted, not the fault of the prosecution. In your circumstances, the prosecution accepted your counsel's submission that suspended sentences would be within range for the state offences, but that submitted that a Section 19B bond was not appropriate for the Commonwealth offence. That matter should be dealt with by way of a fine with conviction. I'll now turn to my assessment of these submissions and imposed sentence, and I'll start with you, Geoffrey Clark. Geoffrey Clark, it is, as all counsel recognised, difficult to reconcile the conflict between the good that you have done and the wrongs that you have committed. This is a particularly complex sentencing exercise. You did not have a privileged upbringing, far from it. I acknowledge that as a relatively young person, you were thrust into the responsibility of administering the Framlingham community without the sort of training and support that was really required. The significance of that fact was underlined in the evidence given at each of your trials by Mr. Ian Ham. Mr. Ham is a Yorta Yorta man with a distinguished career in Aboriginal affairs and a former executive director of Aboriginal Affairs Victoria, which was responsible for administering the Aboriginal Lands Act. And it was to Mr. Ham that the complaints of your mismanagement of the trust were directed when this offending first came to light. In his evidence, he explained that from the 1850s onwards, Aboriginal people were rounded up, taken from their land, often forcibly, and placed and kept on missions. The purpose of the Aboriginal Lands Act was to confer collective community ownership of the lands on which there had been such missions to the local communities. Framlingham had been such a mission. The Framlingham Aboriginal Trust was established under the Act to manage the community. Aboriginal Affairs Victoria's role was to support the Trust with basic funding, oversight, and I infer guidance. Mr. Ham conceded that in respect of the Framlingham Aboriginal Trust, Aboriginal Affairs Victoria had been, and I quote, irregular in its responsibilities under the Aboriginal Lands Act because AAV had been preoccupied with problems in other areas. It seems that over many years the Trust was not given the practical support as to governance and administration which should have been provided. As I explained below, you exploited the resulting weak governance structures. Nevertheless, it is to be regretted that they were weak in the first place. Had the Framlingham community, including you, been provided with the guidance and support as the Act envisaged, things may have been different. None of that is to excuse your dishonesty, but it contextualises it somewhat. In spite of that lack of practical support and guidance, you achieved much in putting in place the sort of infrastructure and economic initiatives that appear to have been steering the community towards self-determination. As Mr. Ham explained in this context, and I quote, "The idea of Aboriginal economic independence is a key notion to self-determination," unquote. Unfortunately, the financial structures developed in tandem with that progress lacked adequate oversight and accountability. Your defence in the first trial was to the effect that either the community authorised the payment of your personal legal fees or that the prosecution could not prove beyond reasonable doubt that it did not. It was a defence that in many respects relied on the community's weak governance to sow doubt. The jury rejected that defence. By its verdicts, it found that you had engaged in a carefully calculated course of conduct over many years to divert community funds for your own personal purposes. I accept, as the prosecution contended, that over time you did develop a sense of entitlement in which you came to treat the community's financial resources as your own. In the various ways in which these funds were perpetrated, you contrived to conflate your own personal interests with the interests of the community. In so acting, you emphatically betrayed its trust. The evidence adduced during the trials exposed your duplicity. To use but one example to illustrate that point, the minutes of the Framlingham Aboriginal Trust Annual General Meeting held on 22 November 2006 recorded the then Chair, Lionel Harradine, reporting that these were difficult times for the Trust and the community because the Commonwealth had advised that it would stop funding the core operations of the Trust at the end of June 2007. Mr. Harradine noted that, and I quote, "There is no way the community can pay for water, sewerage, rates, insurance, etc." unquote. The minutes for that meeting also note that you presented the auditor's report. The note is in the following terms, and I quote, "Auditor's report, Geoff Clark presented the auditor's report. Noted that the financial position was difficult and that staff would have to be put off at Christmas because could not afford to pay all termination pays. Shortfall of around $100,000. Also, that the community will suffer because the level of service will have to be dramatically ceased towards 2007, unquote. By the time you came to give that auditor's report, you knew you had stolen hundreds of thousands of dollars from KWCI to pay your personal legal fees. You also knew that had it not been for your dishonesty, the community's financial position would not nearly have been as dire. Knowing all of that, you would then go on to steal $25,000 from the trust itself in January and February of 2007. That example shows starkly how you abused the community's trust. I accept the prosecution contention, consistent with the verdicts of each of the three juries, that in the various ways in which you manipulated the relevant entity's accounts and actively concealed your dishonesty, you exploited the weak governance structures in place at the time. Part of concealing that offending involved lying on oath as to your non-ownership of your real estate, as well as lying on oath on affidavit and in court as to your shareholding in the trust. It needs to be well understood that lies told in that context are always viewed seriously by the courts because of their capacity to undermine the administration of justice. The Crown's contentions as to your high moral culpability should be accepted. The total amount you stole approaches $1 million, although the Trust recovered the $400,000 you transferred to KWCI. The balance of what was stolen was money that your community sorely needed. You profited from unfair transactions from other community members. Whether or not the value of shares as calculated under the Act was a realistic value, you knew of the Act's requirements and you failed to disclose them to Ms McDowell. Whatever their precise worth, you dishonestly obtained those shares for far less than their real value. In short, you stole on multiple occasions in a variety of ways to personally benefit and or strengthen your power and influence in the community. That you did so, having otherwise achieved so much, is profoundly disappointing. What you did was aptly described as morally reprehensible. As one Framlingham elder who sat on the Trust's Committee of Management put it, and I quote, "I have faith in people, I had faith in them, trust," unquote. The maximum penalties for the offences for which you must now be sentenced were accurately set out in the Crown's amended outline of prosecution opening for plea, and I need not set them out here. Suffice to make the point that whilst those maximum penalties, together with current sentencing practices, provide guideposts to the sentences to be imposed, they cannot be determinative. They are but two of the many factors that Parliament has prescribed and to which I have had regard. The parties did not refer to or rely upon comparative cases that might show relevant similarities or instructive differences with this case. That is not a criticism at all. I infer there are no such authorities because of the unique complexities thrown up by this case. I have considered carefully whether the principles in sentencing white-collar offenders apply to you as the prosecution contended. I have concluded with one qualification that they do. It makes no difference that most of these offences were committed in a small office in Framlingham, as distinct from a more conventional locus for corporate criminality. The effect is the same, abuse of authority with significant financial loss. The qualification arises out of your history of disadvantage and Mr Ham's concession to the effect that Aboriginal Affairs Victoria's support and guidance was lacking. As I've explained, that contextualises your circumstances somewhat and is perhaps a point of distinction from more typical white-collar offenders. That qualification aside, the point made by Justice of Appeal Charles in the passage cited from Borfin at paragraph 133 as to the difficulty of detection of this kind of offending is very much apposite here. It took a great deal to investigate and expose what you have done. It took a great deal to prosecute it. Those that did so should be acknowledged. As a matter of principle, those difficulties as to detection and the prosecution of the offending mean that general deterrence will carry particular significance, and that must be so in your case. It follows that I cannot accede to your counsel's submission that a sentence of 12 months or less could be imposed in combination with a community correction order. The need to demonstrate to others that dishonesty such as yours will be denounced and punished will be the primary objective of the sentence imposed on you. Despite the emphasis I must give to those sentencing objectives, those punitive sentencing objectives, I must still carefully weigh the matters personal to you. The delay attending these proceedings will mitigate. Through a lengthy investigation, through the pandemic, and through a lengthy trial process, this matter has been hanging over your head for nearly 6 years. I accept that delay has been punitive. In addition, you have not reoffended whilst the matter has been pending. On the evidence before me in the form of the many testimonials, there can be little question that as a leader of your people on the national stage, you fearlessly advocated in their interests. In so doing, you did much good. To paraphrase what Justice Callanan said in Ryan, much of the shine of that good has been lost by the abuse of the trust placed in you by your community, but not all of it. Character is not a one-dimensional feature of any person. You are, as your counsel contended, entitled to rely on your otherwise good character and what I accept must be at least reasonable prospects of rehabilitation. Despite the suggestion that you remain or wish to remain involved in trust affairs, I do not accept the prosecution contention that it is particularly necessary to emphasise specific deterrence. Your advanced age and serious chronic medical conditions weigh on you and will do so all the more in prison. The investigation has exposed your wrongdoing and attracted opprobrium. I do not expect that you are likely to be able to reoffend upon release. You are not to be punished for pleading not guilty to these offences, although by the same token you are not entitled to the reduction in your sentence that would otherwise flow from a plea of guilty. There is no evidence of remorse. Your counsel referred to the need to apply the principle of totality carefully in your case, and I agree. That principle requires me to ensure that the overall sentence imposed remains just and appropriate, despite the number of offences committed. Whilst I must generally try to recognise the separate criminal acts represented by each charge, the orders for cumulation will be moderated to give effect to that principle. In a similar vein, giving due weight to the matters favourable to you, such as delay, your ill health, your advanced age, and your otherwise good character, I will moderate the sentences I impose. In particular, the non-parole period will be shorter than might otherwise be so. I will now move to sentence with respect to Geoffrey Clark. Taking all relevant matters into account, you will be sentenced as follows. On the first trial indictment, point A1, on charge 4, theft, from KWCI, you will be convicted and sentenced to 15 months imprisonment. On charge 5, theft from MLC, you will be convicted and sentenced to 24 months imprisonment. On charge 9, theft from MLC, 22 October 2003, you'll be convicted and sentenced to 15 months imprisonment. On charge 10, theft from KWCI, you will be convicted and sentenced to 9 months imprisonment. On charge 11, theft from KWCI, you will be convicted and sentenced to 12 months imprisonment. On charge 12, theft from KWCI, you will be convicted and sentenced to 9 months imprisonment. On charge 13, theft from KWCI, you'll be convicted and sentenced to 12 months imprisonment. On charge 14, theft from KWCI, you will be convicted and sentenced to 12 months imprisonment. On charge 16, theft from KWCI, you will be convicted and sentenced to 9 months imprisonment. On charge 17, theft from KWCI, you'll be convicted and sentenced to 12 months imprisonment. On charge 19, theft from KWCI, you'll be convicted and sentenced to 12 months imprisonment. On charge 20, theft from KWCI, you will be convicted and sentenced to 12 months imprisonment. On charge 21, theft from Framlingham Aboriginal Trust, you will be convicted and sentenced to 12 months imprisonment. On charge 22, theft from Framlingham Aboriginal Trust, you will be convicted and sentenced to 9 months imprisonment. On charge 23, theft from KWCI, you will be convicted and sentenced to 12 months imprisonment. On charge 24, obtaining a financial advantage by deception from KWCI and Framlingham Aboriginal Trust, you will be convicted and sentenced to 15 months imprisonment. On charge 25, obtaining a financial advantage by deception from KWCI and Framlingham Aboriginal Trust, you will be convicted and sentenced to 9 months imprisonment. On charge 26, obtaining a financial advantage by deception from KWCI and Framlingham Aboriginal Trust, you will be convicted and sentenced to 15 months imprisonment. On charge 27, statutory perjury, you will be convicted and sentenced to 15 months imprisonment. I will declare pursuant to section 6J of the Sentencing Act that in respect of charges 4, 5 and 9, being continuing criminal enterprise offences, you have been sentenced on those charges as a continuing criminal enterprise offender, and I'll cause that declaration to be noted in the records of the court. I will order that 4 months of the sentence imposed on charge 27 be served cumulatively upon the sentence imposed on charge 5. I will order that 3 months of the sentences imposed on each of charge 4, charge 9, charge 24 and charge 26 be served cumulatively upon the sentence imposed on charge 5. I will further order that 1 month of the sentences imposed on each of charge 10, charge 11, charge 12, charge 13, charge 14, charge 16, charge 17, charge 19, charge 20, charge 21, charge 22, charge 23 and charge 25 be served cumulatively upon the sentence imposed on charge 5, rendering a total effective sentence on this indictment of 4 years and 5 months. Turning to the second indictment, the indictment point 2A from the third trial. On charge 1, theft from KWCI, you will be convicted and sentenced to 12 months imprisonment. On charge 3, knowingly deal with proceeds of crime from Framlingham Aboriginal Trust, you will be convicted and sentenced to a term of imprisonment of 15 months. I will order that 3 months of the sentence imposed on charge 1 be served cumulatively upon the sentence imposed on charge 3, rendering a total effective sentence on this indictment of 18 months imprisonment. Turning then to the fourth trial and indictment point 3A. On charge 2, obtaining a financial advantage by deception from the estate of Robert Clark, you'll be convicted and sentenced to a term of imprisonment of 15 months. On charge 3, theft from Framlingham Aboriginal Trust, you will be convicted and sentenced to a term of imprisonment of 21 months. On charge 4, statutory perjury, you will be convicted and sentenced to a term of imprisonment of 15 months. On charge 5, giving false evidence in a Commonwealth judicial proceeding, you will be convicted and sentenced to a term of imprisonment of 15 months. I will order that 4 months of the sentence imposed on charge 4 be served cumulatively upon the sentence imposed on charge 3. I will order that 3 months of the sentence imposed on charge 2 be served cumulatively upon the sentence imposed on charge 3. rendering a total effective sentence on the state charges of 28 months. I will further order that the Commonwealth sentence on charge 5 commence 17 months from this day, that is 29 April 2026, and otherwise run concurrently with the state sentences. I will decline to fix a non-parole period in respect of the Commonwealth sentence because an overall non-parole period will be set with respect to all sentences. The overall total effective sentence of imprisonment on this indictment will therefore be 2 years and 8 months. Turning then to the overall total effective sentence, I will further order that 6 months of the sentence imposed in respect of indictment C1812137.2a and 15 months of the sentence imposed in respect of indictment C1812137.3a be served cumulatively upon the total effective sentence imposed on indictment C1812137.A1, rendering an overall total effective sentence of 6 years and 2 months. I will fix a non-parole period of 3 years and 9 months. I will declare, pursuant to Section 18 of the Sentencing Act, that you have already served 78 days of pre-sentence detention, and I will cause that declaration to be noted in the records of the court. I will now turn to my assessment of the submissions relating to Jeremy Clark. Jeremy Clark, I accept that your role in this offending was very much at the behest of your father. He was the driving force and sole beneficiary of this offending. You did not receive any personal benefit. Both the prosecution and your counsel characterised your motivation as arising out of misplaced loyalty. I accept that that was so. You were relatively inexperienced in carrying out the responsibilities of running the trust and KWCI whilst your father was in Canberra. He was a prominent Aboriginal leader with a powerful personality. He would have been a hard man to say no to. That said, your role was not entirely passive or morally blameless. For example, of the $231,960 which you assisted in stealing to pay for your father's personal legal fees, $150,000 was taken from the Maar Land Council in 2 transactions in 2003. On 2 October 2001, you wrote a letter to the legal officer of the Mirrabee Nations Aboriginal Corporation in your capacity as MLC Regional Agreements Facilitator. In that letter, you refer to the agreement struck after the Maar Land Council convened a number of meetings involving the Kirrae Warring Native Title Group. And you state in that letter as follows, and I quote, "Subsequent compensation benefits of $100,000 have been received by the Maar Land Council, the trustee, and deposited into its bank account to be held in trust. This was done as per instructions at a Maar Land Council meeting for September 1999. The instruction was as follows. All the monies from any agreements will be put into a trust account until genealogies have been done and there is agreement on who will benefit from these agreements. A further $50,000 is to be paid upon registration of the ILUA. If, when this money is received, it will be deposited into the Maar Land Council account and held in trust until the proper processes are in place to disperse it." Unquote. In the transactions the subject of those charges, you must have appreciated that not only was this money being diverted for your father's personal benefit, but that it was at the cost of the rightful entitlement of native title holders. As that example demonstrates, whilst your role was subsidiary, it was nevertheless knowing and culpable. That said, there is much that now mitigates. The delay since you committed these offences is extraordinary. It is in the order of 11 years from the Farcasia offending and 20 years from the legal fees offending. I accept your counsel's contentions that since being charged you have had to step back and forego the opportunity to contribute to First Nations affairs at a high level, and that has been punitive. You appear to have moved on and out from what might be described as your father's shadow. The quality of the character evidence establishes that you are well placed to continue to advance the interests of First Nations people, both in the construction industry and, once these matters are finalised, in the wider community. I accept as your counsel contended that you are now a very different person to the person that committed these offences, and that it is not just a case of having good prospects for rehabilitation, rather you are in fact rehabilitated. The sentencing regime applicable to offending at this time enabled the imposition of sentences of imprisonment to be wholly suspended if a court was satisfied that it was desirable to do so. I consider that in your circumstances it is desirable to do so. That course was not opposed by the Crown. I'm satisfied that the sentencing purposes of general deterrence and denunciation can be adequately reflected in sentences of imprisonment that are wholly suspended. I consider that it is very much in the longer term interests of the community that what you have now achieved not be jeopardised by placing you in prison. Given your sister-in-law's tragic death and the vagaries of the relevant funding arrangements, I consider that the Farcasia offending encompasses a unique set of circumstances that merits leniency. In addition, you're entitled to a substantial reduction in sentence because of your plea of guilty. I cannot, however, accept that only nominal punishment is appropriate. Whilst I'm prepared to deal with the matter by placing you on a bond to be of good behaviour, I have determined that it is appropriate to record a conviction for that offending. Taking all relevant matters into account, you'll be sentenced as follows. With respect to the second trial and indictment C181213.B2, on charge 4, theft from MLC, you'll be convicted and sentenced to a term of imprisonment of 18 months. On charge 7, theft from MLC, you will be convicted and sentenced to a term of imprisonment of 12 months. On charge 8, theft from KWCI, 7 April 2004, you will be convicted and sentenced to a term of imprisonment of 6 months. On charge 9, theft from KWCI, 13 April 2004, you'll be convicted and sentenced to a term of imprisonment of 9 months. On charge 11, theft from KWCI, you'll be convicted and sentenced to a term of imprisonment of 12 months. On charge 12, theft from KWCI, you will be convicted and sentenced to a term of imprisonment of 9 months. On charge 15, false accounting from Garryword, you will be convicted and sentenced to a term of imprisonment of 12 months. I will order that 2 months of the sentences imposed on charges 7, 11 and 15 be served cumulatively upon the sentence imposed on charge 4. I will further order that 1 month of the sentences imposed on charge 9 and charge 12 be served cumulatively upon the sentence imposed on charge 4. The sentence on charge 8 will be wholly concurrent. That renders a total effective sentence of 2 years and 2 months imprisonment. I will further order that all sentences of imprisonment imposed on this day be wholly suspended for a period of 2 years. With respect to plea indictments C181213.1c, with respect to the rolled up Commonwealth offence of dishonestly obtaining a gain, pursuant to section 20, subsection 1A of the Crimes Act, you will be convicted and ordered to be released upon you entering into a reconnaissance in the sum of $1,000 to be of good behaviour for a period of 2 years. I am obliged to explain the effect of that last order, and that it will be that should you commit an offence punishable by imprisonment over the next 2 years, you will be brought back before me and liable to be resentenced for that offence. I will declare, pursuant to section 6AAA of the Victorian Sentencing Act, that but for your plea of guilty with respect to the Commonwealth offence, you would have been sentenced to a term of imprisonment of 6 months.